you emphasized how notions and conceptions of restorative justice are part of South Africa's legal and juridical life. That's a precedent that exists in South Africa. So it's odd that this is something that South Africans struggle to resonate with, considering the fact that how we understand justice is rooted in these conceptions of justice, which make the normative switch of emphasizing how wrongdoing that happens within the community isn't only the problem of the individual wrongdoer, but it is the problem of the community and the conditions that community creates that raises up this individual wrongdoer. And this is something that's rooted in African conceptions of justice and should be articulated as such. So how do we get people to reach that place where we say this isn't something that we're importing from America, but this is something that is foundational to how we as Africans have always conceived of justice. And once we do that, we say, well, once we understand wrongdoing, moving past the level of the individual, we look at their circumstances and their social and economic circumstances and changing their behavior by changing those underlying circumstances.
Yeah, so I mean, great point. One of the questions I always get whenever I'm speaking about abolition is like, or at least the comments that I get is, yeah, that's fine if you're a professor or if you're in one of these Nordic or Western countries, but how does that apply to us, to us here in South Africa? Like, that's un-African. And it's strange because, as you point out, that's the furthest thing from the truth. So, one of the things I discuss in my dissertation is this idea of prisons, like I said earlier, as colonial imports, but not just as colonial imports, but as integral to upholding the aims of colonialism. So racial superiority, economic exploitation, and just political suppression. I think that it's an interesting question to say, how do we get that to people in general? Something that I think is interesting, because obviously, the average South African is probably not going to read my dissertation, unfortunately.
Probably not.
Yeah.
I was doing
a lot of South Africans still live under, or to some extent experience, customary law, right? So traditional African law. In KwaZulu-Natal, which is the province that I'm from, large amounts of people may not live permanently in more rural areas, but at least have a home somewhere in rural KZN where they still live to some extent under the jurisdiction of the Zulu king, or under certain headmen. And I'm obviously not making the argument that, these are groups of people who don't experience just general South African law, because they most obviously do. And I'm also not making the argument that customary law is perfect. But, when I studied customary law, which unfortunately is like a single module in the syllabus as a law student, one of the things we learned was that under customary law, rape is not a crime. It is what Western lawyers would consider a delict. So it's a civil claim, right? And at the time we were taught that was terrible and a really bad way of doing things, because you're essentially claiming damages. And unfortunately, it's damages that go to a woman's father very often. And yes, there are concerns there, but I think it is important to note that what that should tell us is that customary law looks at issues of rape or even of violent crimes in a very different way than just general law does. And customary law is a type of law that many people experience on some level in South Africa. And so there's a lot of scope, I think, looking at it through that perspective, to think about how customary law can be developed with the influence of community leaders and traditional leaders, so that it is restorative in nature, which it already is, but still compliant with, I guess, some of the tenets of our constitution and the dignity of women. And that's something that South African courts have done before, right? When they've interacted with customary law through, for example, inheritance matters and whether or not, men only can inherit or women can. And they've had very progressive judgments, but something that's interesting to note is it hasn't been the court imposing progressiveness onto customary law. It's been a matter of people going to the courts to say, customary law is living, it develops, it has developed in a way that is progressive, but the way it's been codified isn't progressive. And so all we need you as a court to do is recognize the living progressive nature of customary law. And I think that's something that could happen here in terms of the way the customary law thinks about rape and sexual offenses, but also in terms of the way that the law in general interacts with customary law and incorporates it, because unfortunately we have a system in South Africa where we relegate customary law to the sidelines. And so, yeah, like you said, Will, I think more needs to be done by our courts to incorporate, values of Ubuntu and restorative justice into the mainstream, and not just into big constitutional court cases, but in the everyday criminal case.